Welcome to Chapter 4, Global Data Protection Landscape. In this chapter, we'll explore international data protection standards, including GDPR, OECD guidelines, and APEC privacy framework, along with challenges like cross-border data flows, jurisdictional complexities, and data sovereignty. In this chapter, we will examine the global data protection landscape, focusing on international standards for data protection and the challenges associated with cross-border data flow and jurisdiction. As businesses and technologies become increasingly global, data protection laws need to adapt to an interconnected world where personal data is often processed across multiple jurisdictions. International standards for data protection. In an interconnected world where data flows freely across borders, the development of international standards for data protection has become crucial. These standards help ensure that data protection laws are consistent, enabling the responsible collection, processing, and transfer of personal data across jurisdictions while respecting individuals' privacy. Key international standards. The GDPR, implemented in 2018, is one of the most comprehensive and influential data protection regulations globally. It governs the collection and processing of personal data by organizations operating within the EU and applies to non-EU organizations processing personal data of EU residents. Key provisions of GDPR. Consent. Data can only be processed with explicit and unambiguous consent from individuals. Right to access and rectification. Individuals can access their data and request corrections or deletions. Right to erasure. Right to be forgotten. Individuals can request their data be deleted when it is no longer necessary for the specified purpose. Data portability. Individuals can transfer their personal data from one service provider to another. Data protection by design and default. Organizations must implement security measures from the outset of any project. Data breach notification. Organizations must notify authorities and affected individuals within 72 hours if there is a data breach. Impact. GDPR has set a global standard for data privacy and has influenced data protection laws worldwide, providing a model for countries to enhance their own regulations. The OECD Privacy Guidelines. The OECD Privacy Guidelines were developed to promote consistency and harmonization of privacy laws across its member countries. These guidelines emphasize key principles of data protection to ensure that personal data is collected, used, and stored responsibly. Key principles of OECD guidelines. Collection limitation. Personal data should only be collected for lawful and specific purposes. Data quality. Data must be accurate, relevant, and necessary for the purpose it is collected. Use limitation. Data should only be used for the purposes it was collected and not for unrelated purposes. 3. APEC Privacy Framework, Asia-Pacific Economic Cooperation. The APEC Privacy Framework offers guidelines that balance privacy protection with the free flow of information across the Asia-Pacific region. It aims to create a more transparent, accountable, and consistent privacy framework among APEC economies. Core principles of APEC Privacy Framework. Notice: organizations must inform individuals about their data collection and usage practices. Choice: individuals should have the ability to opt out of data processing. Access: individuals should have the right to access their personal data and make corrections. Accountability: organizations are held accountable for how they process personal data. United Nations Guidelines on Privacy and Data Protection. The United Nations (UN) Guidelines on Privacy emphasize human rights in data processing. The UN advocates for privacy laws to be rooted in the protection of individuals' fundamental freedoms and human dignity. Key principles in UN guidelines. Lawfulness and fairness. Data processing must be lawful, fair, and transparent. Transparency. Individuals must be clearly informed about the collection and processing of their data. Security and accountability. Organizations must have robust security measures in place to safeguard personal data and must be held accountable for their data protection practices. Cross-border data flow and jurisdictional challenges. As data flows across borders, businesses are required to manage cross-border data transfers, navigating varying data protection regulations in different jurisdictions. This is increasingly complex due to differing laws and concerns over data sovereignty and regulatory enforcement. Cross-border data flow and jurisdictional challenges. As data flows across borders, businesses are required to manage cross-border data transfers, navigating varying data protection regulations in different jurisdictions. This is increasingly complex due to differing laws and concerns over data sovereignty and regulatory enforcement. Challenges of cross-border data flow. 1. Inconsistent regulations across jurisdictions. Countries have different levels of data protection laws, which leads to challenges for businesses operating internationally. For example, the EU's GDPR imposes stringent rules for data transfer outside the EU, such as using standard contractual clauses, SCCs, and binding corporate rules, BCRs, for non-EU countries. Meanwhile, some countries have more relaxed laws, which complicates compliance for global organizations handling data across borders. Number 2, the impact of GDPR on global data transfers. GDPR restricts the transfer of personal data to countries outside the EU unless they ensure an adequate level of protection. Adequacy decisions are made by the European Commission, and only countries deemed to offer an adequate level of protection are eligible for data transfers without additional safeguards. The Schrems II ruling in 2020 invalidated the EU-US Privacy Shield, which had previously facilitated EU-US data transfers, highlighting the importance of reviewing mechanisms like SCCs for international data exchanges. 3. Data sovereignty. Data sovereignty refers to the idea that data is subject to the laws of the country where it is collected or stored. Countries with strict data protection laws, such as China or Russia, may require organizations to store and process data within their borders. For instance, China's cybersecurity law mandates that personal data must remain within China, creating compliance challenges for global organizations that handle sensitive personal data. Enforcement and regulatory authority. A major challenge of cross-border data flow is the enforcement of data protection laws. When data is transferred across borders, it may fall outside the jurisdiction of the original country's regulators. This creates difficulties in ensuring compliance and holding organizations accountable for data breaches. However, international agreements and frameworks like the EU-US Data Privacy Framework aim to address these challenges by setting guidelines for secure data transfers. 5. Harmonization of data protection laws. Efforts are underway to harmonize data protection laws globally. Initiatives like the OECD Guidelines, APEC Privacy Framework, and Council of Europe's Convention 108 are aimed at aligning international data protection standards. Such harmonization simplifies compliance for global organizations and ensures that individuals' privacy rights are protected in all jurisdictions. 6. Extraterritoriality of data protection laws. Many modern data protection laws, such as the GDPR, have extraterritorial reach. This means that businesses outside the jurisdiction may still be subject to a country's data protection laws if they process personal data of individuals in that country. This creates legal complexities as businesses must navigate multiple data protection regulations, even when operating outside their home jurisdiction. Key takeaways: global standards for data protection. International frameworks such as the GDPR, OECD guidelines, and APEC Privacy Framework provide universal principles for protecting personal data. These standards form a foundation for global privacy protection and ethical data processing. Cross-border data challenges. Global data transfers are essential for business operations, but they present challenges related to regulatory compliance, data sovereignty, and enforcement. Businesses must navigate these complexities to ensure legal compliance in all jurisdictions. Extraterritorial reach of laws. Data protection laws like GDPR are often extraterritorial, meaning they apply even to businesses outside the jurisdiction if they process personal data of individuals in that region. Understanding these global obligations is essential for compliance. The need for harmonization. Efforts to harmonize data protection regulations globally will facilitate smoother data transfers while ensuring consistent protection for personal data. Organizations should stay informed about ongoing international agreements and regulatory changes. In the next chapter, we will delve into Chapter 4 of the Digital Personal Data Protection Act, DPDP 2023, focusing on the obligations of data fiduciaries under the Act and the responsibilities they bear in safeguarding personal data. This chapter explored the international standards for data protection and the challenges that arise when dealing with cross-border data flows and jurisdictional issues. These considerations are vital for global businesses to understand as they navigate the complex world of data privacy and protection. Thank you for joining this session. In the next lesson, we will explore the introduction to the Digital Personal Data Protection Act 2023, diving deeper into how this vital code operates. See you soon. Don't forget to subscribe to our channel for more valuable legal insights and updates. youtube.com/prolegalminds. If you have any legal questions or need assistance, visit us at prolegalminds.com to connect with our expert team. We're here to help you navigate the complexities of the law with confidence. Stay informed, stay empowered. See you in the next session.